And welcome to yet another edition of Out of the Court. This is episode number 3. I'm Barry Davis, along with my criminal lawyer pals, Scott Cowan, Adam Goodman. Gentlemen, it has been a very busy week. I just wanted to get your final thoughts on everything that went down with Roberto Osuna, because there still are a lot of unanswered questions about this. And my first question to both of you is, by the woman not coming here to testify, does that look good on Roberto Osuna's case that, well, she doesn't have a case against me, this is why she didn't come? Or is this a negative that she was afraid to come out here and maybe spill the beans on what really happened?
I think it creates a lingering doubt, at least in the mind of the public, in the sense that she didn't come and say it didn't happen, or she didn't come and have her story found to not be credible.
We didn't even hear her story. They didn't even mention the narrative. They didn't give you a snapshot in court of what her story ever was.
No, and as I told you the other day, I was quite surprised by that. Usually there's some type of a factual basis before entering a peace bond, and we didn't even get that.
I think one of the big questions that came out from a lot of people is, if he truly believes he did nothing wrong, why would there be a peace bond? Why would he accept a peace bond, especially when one of the words and the fancy terms you guys were using, and I don't even remember what it was, that there wasn't enough evidence, there wasn't enough cause for him to be convicted. Why then say, I'm going to do a peace bond? If there's not enough to convict him, wouldn't he just say, okay, I'm pleading guilty, and it's going to be withdrawn?
Pleading not guilty, you mean?
Yes.
Yeah. He probably could have done that. Based on what the Crown said, they had no case, and the Crown has no case. He has no obligation to enter any order at all. And going back to your first question, in the eyes of the public, I agree with Adam. In the eyes of us who do a lot of domestic allegations, what it looks more like to me is that she wishes to have a positive pro-social relationship with him going forward. She wants that contact with him. They have a child together. He presumably will be a good provider going forward, and maybe even a good role model, despite this allegation. It sounds like she wants to bury the hatchet, to borrow an old phrase.
It sounds like
it does. It doesn't mean nothing happened to me, knowing how the system works. In fact, maybe even the opposite. Many times when a complainant is reluctant, it's because something did happen. They are reluctant to talk about it, but wish to move forward without.
But if she's not coming back, Scott, if the Crown is not going to have that evidence, why sign the peace bond?
I agree. He doesn't have to. And if the Crown has no reasonable prospect of conviction, they're not supposed to proceed with anything.
Well, that's what I found interesting. The Crown stood up and said, Your Honor, there is no reasonable prospect of conviction. And the Crown, as a Minister of Justice, has an obligation, once she makes that independent assessment on her own, which no doubt she did quite well, her obligation is then to withdraw the charge. So the Crown makes that statement and then says, Your Honor, I'm laying a peace bond before the court. The only thing I can think of is, let's say she said, you're welcome to show cause here. Could they have show caused that peace bond without her testimony? And that's where the question is, was there a video, might come into play.
Yeah, they can. They don't need to have live evidence. It's not the same rules of evidence for that motion. They get preventative recognizances from high-risk offenders leaving penitentiaries, for instance. They get them against terrorism suspects. They get them against known or thought to be sexual predators on paper records without full adjudication.
And maybe the agreement was, we're not going to read the facts into the record. But if the Crown said, well, I'm going to lay the peace bond no matter what, then there's going to be facts read in.
He doesn't want any hearing at all that brings out facts for his public relations and public profile. So that's probably why it happened the way it is. Barry, you ask why sign it? Because it is, this is no pun intended, it's a peaceful way to resolve it. It's a harmonious handshake type way to put this behind.
you mentioned that he doesn't want any evidence to come out or video to come out that could show, but if he believes he did nothing wrong, then why would he care? Like, you know what I'm saying? Like, is this almost, without him saying, I did do something I shouldn't have done, him saying, well, I did something I shouldn't have done? Is that now become an obvious because there was a peace bond, because he agreed. I mean, we talked about agreeing to the suspension, but that could have all been a prerequisite for, if you want a peace bond, you're going to have to accept this and not fight it.
I don't think the Ontario Crown would have been involved in the Major League Baseball administrative decision to suspend. I don't think so. I don't know who they consulted and what other collateral consequences they considered on either side, either decision maker, the Major League Baseball discipline commissioner or committee that ever made that decision, or the Ontario Crown. What you can take from this is that there was some evidence of a breach of the peace, meaning there was some disruptive, probably antisocial behavior on both or one of the two parties involved, and that the court is ordering him or finding a basis to say it would be better if you promised to keep the peace, which is a pretty low standard. Whenever I want a client to take a peace bond, whenever I think it's in their best interest, I say, all you're really promising to do is what the social contract tells all of us to do, which is keep the peace and be of good behavior. It's not asking much.
No, I agree with what he's saying. There was a deal that was made here, and this happens all the time. And as I explained to you, there was a judicial pretrial in chambers with Justice Green and the Crown and Osuna's lawyer, and all of these things would have been presumably worked out. And unfortunately, the result is we're kind of left where we were when this whole thing started, in that we have very little information.
And we have more questions now than ever before, because now Roberto Osuna, in the eyes of the law, is a free man with no criminal record. And you're also having this concept from the woman saying, I want to co-raise the child. She's living in Mexico. He's living here.
In Houston.
Yeah, well, yeah, in Houston. When here is in,
Well,
almost
until the
forgot he got
season's
traded.
over in Houston.
Yeah, and then he goes to Mexico. But the point is, for them to co-raise the child, would that almost be like a divorced couple that, shared custody? Or co-parenting, does that mean that they would they plan to coexist as a family?
Well, I expect we don't know the nature of the relationship. They had a baby together. They weren't married.
And this isn't the only baby that he has either. We should...
Oh, I didn't know that. But the Crown wasn't going to say if this was going to continue to be a romantic relationship or if they were just going to parent the child together. It's one of those things that's going to be quite unclear.
But if she felt that she wanted to reconcile with Roberto and thought, okay, the best thing for me to do is to just say, look, it was overblown, nothing happened, I forgive him. Is I forgive him enough for the law to say, all right, well, if she forgives him, then there's no need for us to proceed with this? Because hypothetically, there still could have been an assault caused, but if she's, whether out of fear or out of love, says, no, I'm okay.
No, it's not, and it shouldn't be. And that's one of the problems with domestic allegations, in that all the time we see people charged with domestics, and then the complainant or somebody's wife, or if it was a man charged, the husband or the girlfriend, boyfriend, whatever it is, come and say, I want to drop the charges. And these are phone calls that, as criminal lawyers, we get all the time from complainants saying, I want to drop the charges. And we have to explain, no, it's in the purview of the state. And the reason for that is to protect the complainants, in that it just happens all the time that people are in a romantic relationship and they want to move on with their lives. And sometimes there's benefit to that, in the sense that you've broken people's lives up as a result of an allegation, and you're giving them an opportunity to put the pieces back together. But we also don't want people who are being abused to be able to just come back and say, no, let's drop these charges, which is why it's ultimately the state's decision to drop them.
There's a public interest in intervening with someone who's committing domestic violence. There's no question.
Exactly. But in this case, ultimately, her refusal to come back made it impossible for the Crown to prove their case. It's very difficult, not always impossible, certain more complicated types of statements, to prove a case without the complainant. But generally speaking, it's rare to see a conviction without a complainant coming and testifying that some criminal activity occurred.
So then how did Major League Baseball come up with a 75-game suspension? You know what I'm saying? Like, did she Could they have spoken to her could Major League Baseball spoken to this woman on the phone and say, what happened? And then she says, he did this, this, and this. And they're like, okay, that's enough for us to lay down this 75-game suspension. Compare that to a court of law. Could they have just gotten a testimony over the phone or a written testimony?
That's the difference.
The Crown can get her input by telephone. They can get anybody they want.
And the difference is, in order to prove a case in a court of law, you need evidence that's essentially sworn testimony. And her statement that she might have told the police, if it wasn't sworn or affirmed at the time it was given, it's not admissible for what we call the truth of its contents, whereby MLB taking information or a statement over the phone, they might be able to admit it within the confines of their rules of evidence at their hearing. And absent Osuna coming and saying otherwise, him essentially saying, I don't want to say anything, MLB was left with just her story.
A peace bond, and we've talked about this and kind of broken down what a peace bond is and what it means, but basically it will protect this woman from any other possible wrongdoings if that's in fact what had happened. But my question is, what protection are there from any future women that he may meet? If he is prone to do something like this, right, is there anything the law can do and say, okay, there's this peace bond, so if there was anything bad going on, we know you're not going to come at her. But what about the other one?
Why do you know they won't come back? He won't come on at her.
Well, I'm just saying, isn't that what a peace bond does?
No,
Is it not protect?
The peace bond says keep the peace and be of good behavior.
Well, and not to communicate with her without her consent.
But allowed to communicate with her.
But it's
with
not
her
a
consent.
But it's not a restraining order.
No.
Right? What's the difference then?
There's she and any other woman he's with. There's no difference. He's ordered to not be assaultive, just like we all are.
So he's making a promise, is what he's doing.
Making a promise not
and
to.
they're trusting him.
Yeah.
But let's also keep in mind, he's going to be in Toronto maybe 3 days a year, unless he comes here for other reasons.
Yeah, but there are women.
She's not in Toronto.
And she's not in Toronto.
Well,
so is this peace bond even enforceable in Houston or Mexico? I can't see why it would be.
No, they are extraterritorially enforceable, but that's difficult to actually, in practice, prosecute. If you can't just meet your wife in Cuba while you're on a probation order from Ontario, you would be breaching it. Now, they may not be able to prove it. That's a different question. But no, the peace bond it means something to him where he is. And if he ever did get into any mischief or bad behavior in Houston, you can be sure a DA down there would say, this man signed a court order in Toronto recognizing his role in some disruptiveness. And that should have raised his...
So, you know something? I think we want to keep talking about Osuna, but that's a fascinating and perfect segue into our next topic, in that what if he throws at somebody's head? Is he now in breach of the peace?
I think we should continue this show on this topic, and then we can do a whole other show on that, because I think there's enough.
You want to do Osuna Part 2?
Yeah, I think there's enough here to
I got
digest.
no problem with it.
Yeah.
Making changes on the fly.
There is something out there that is called, a sexual offenders list. And if somebody does something that I'm assuming that the authorities deem that he could be a dangerous predator, then he gets put on a list. And there are different ways of kind of protecting the public from people that are deemed to be possibly dangerous. So regardless of a peace bond, regardless of how the charges were dropped, who is it that's in charge of saying whether or not they think Roberto Osuna is capable, dangerous to other women, or no, he's just fine to go free? You know what I'm saying? Because yes, in this particular case, the charges were dropped.
It sounds like he did some intensive counseling in support of ultimately having them withdrawn.
And that's the thing too, Scott. I mean, if taking the suspension without appealing wasn't an admission of guilt, wouldn't counseling be in some way saying, because if he didn't do anything wrong, why would he feel he needs counseling? I mean, most of us in society, like whether we're suffering from mental health issues or whatever, aren't just going to say, I'm going to go to the doctor and get something done if you don't think there's anything wrong with you.
My articling principle.
I did say Scott, but that's okay.
Barry, lawyers aren't necessarily social workers. We do like to help people out, no doubt, but sometimes we'll give recommendations to do things like seek anger management counseling because it's going to be helpful for their case. It's going to be beneficial when working out a deal. And he might have thought he didn't need any counseling, but if the Crown says, well, I feel otherwise, we want you to get some counseling, he's going to go and get some counseling as part of the deal.
It sounds so, in some ways, kind of seedy. It's almost like, you go there, pretend that you're getting rehabilitated, even though you don't think you need to be rehabilitated, because it's going to make you look better in the eyes of a court.
I don't think there's anything disingenuous, and I say this all the time when I represent people charged with domestic discord, is I say a relationship coming to the point when someone calls the police is not healthy for some reason or another. But
we don't know if she called the police, do we? Was that revealed?
If the neighbors called the police because they had a concern about some discord,
right?
There's something about the relationship that is, let's say, possibly less than healthy and probably less than healthy. So there's nothing wrong with an accused person saying, I'm going to go out and through my employee assistance program, like the Major League Baseball Players Association has, many corporations have it, or through private counseling, I'm going to go and get myself, this is oversimplification, a clean bill of mental health. Meaning this person has come to see me. I am Dr. Flanagan. I run a private family counseling clinic, and this is a letter I'm writing to this man's lawyer, Cowan, and I'm telling Cowan, this man's seen me 14 times over the last 4 months. We have discussed end of relationship issues. We have discussed jealousy issues. We have discussed his use of alcohol at the end of the workday. And I feel this man is addressing the stresses in his life well.
I have clients who have asserted their innocence, who we've still decided for them to go through the PARS, or the partner assault program, that have come back to me and said, Adam, I got a lot out of that program. It was good for me, even though they claim they were never violent. But maybe there was some type of anger issue that was going on, and they came out with a clean bill of health from it.
Or hard introspection into your life and what mistakes you were making, what buttons you were pushing in yourself or your partner. So there's nothing wrong with it. It's not an admission of guilt. It's tempting to look at it that way. It's tempting to say, took a suspension, took counseling, took a peace bond. Where there's smoke, there's fire. That is tempting, and dollars to donuts, it's right, but it doesn't necessarily mean that. And you would never want to give that chilling effect that says, get counseling, look guilty. So I think as a public policy, we'd never want to let that notion develop too much beyond what is, the common sense is fine, but let's let people heal without judging them too much.
How differently would this case conceivably played out had Roberto Osuna not been a professional ball player or a celebrity? If it was just Joe Blow off the street who was accused of exactly what happened, would we be talking about this? Would there be peace bonds and all that stuff? Or is this a lot of this being done because of the profile that he has?
Just keep in mind, we don't know what happened.
Exactly. Right. The lack of the facts make it hard to judge. What we do know is that the complainant lives in Mexico.
But
that's a unique feature.
Right.
For both her own safety, the provability of the case if she doesn't want to come back. But other than that, though, it's very typical. Many cases will end this way.
You don't find, though, that a celebrity that is being charged with something is handled in a different way than the average person simply because of the amount of attention that's given to the case, the amount of attention that is given to the person that is being charged?
Not in this case. I don't see it here because, as I say, this disposition, a peace bond at the end of a domestic violence allegation is very common. The unique feature is that in a very high-profile way, Osuna was able to say, look, I've already been punished to some extent. A 75-game suspension, half a season, half a professional athlete's salary, whatever his happens to be.
That's almost as much as a lawyer makes in a year.
Well, half of his salary, I don't know what Osuna's salary. I think it was like $500,000. It wasn't that much yet, right? Because it's only his second year.
Yeah, he's
or his third
year,
fourth
year. Yeah.
So I don't know.
But he's not making the millions and millions of dollars.
No. So he had a consequence that was very tangible, a very public shaming that was tangible. So those things you can point to. Mm-hmm. Many times when someone has privilege or a position of power, it may look like they're getting preferential treatment, but really what their lawyers are able to do is, look, there's been a real cost. I've had teachers teaching students lose their careers because of an allegation. And I go to the Crown and say, look, this is what he's already lost. So as far as his own consequences, as far as him feeling the pain of this, he's felt it more than you can possibly do. Whatever the length of your probation order, whatever the size of your $200 or $500 fine, it's nothing compared to what he's already gone through. So whereas if he was a person who was on a fixed disability income, had stable housing, and nothing really happened to his life, I can't point to those collateral consequences the same way. So you may say the teaching kid got a break, not necessarily because he felt in other ways.
If hypothetically this case went to court, how much more difficult is it to select a jury when you are talking about a public figure that in many ways it's hard to find people in the GTA that would be serving on the jury that don't know who Roberto Osuna is? And as we've seen through the social media posts everywhere, people have their decision made up on whether or not he is guilty or he is innocent. How much of a challenge is that? And as a lawyer, like, how much say do you have who's on the jury? I mean, look, here's Scott sitting here wearing two Blue Jays shirts. And I've been in those jury selection committees, and you look around and if I went and there's 200 people in that room, and I asked every one of those 200, do you know who Roberto Osuna is? I bet you 190 of them would say, yes, I know who he is.
A case of this magnitude would have never gone to a jury. It would have stayed in the Ontario Court of Justice. It would have been a judge-alone trial. But speaking as a hypothetical, if it was a more serious case that went to a jury, and we could probably talk for hours on the pros and cons of letting 12 people make a decision on guilt or innocence. But I know I found, although I don't always agree with jury verdicts, that they do tend to take their jobs seriously and should be able to separate themselves from the person.
The closest example we have to this would be Rob Ramage.
Yes.
Rob Ramage went before a jury in Newmarket, Ontario, essentially Toronto. Certainly would have been a neighborhood with its fair share of Leaf fans. And he was was he the captain in the late 80s?
He was the captain, yeah.
And he was found guilty of impaired driving causing death of his friend, who was a former player, and bodily harm of a innocent bystander driver who was, I think, coming the other direction on Highway 9 that fateful night. And the case against him was very strong. His readings were very high. There was perhaps an argument about the continuity of the blood sample, but it was not strong. He was very well represented by Brian Greenspan, and the jury convicted him, I think, rather easily based on the evidence. So whereas a case like this, a domestic case, you'd have a little bit more boys will be boys maybe, whereas impaired driving causing death doesn't really have that same public tolerance for that, the same way we might for just a bad boy who got angry one night.
When you say that, is that the thinking of a judge?
No, a judge would not think that way.
So who would? Because if it's no jury, if it's just
if a judge heard this case, he or she would take it very seriously because of the huge consequences for people who are traveling internationally, performing at a very high level, and would want to apply the reasonable doubt standard with extreme care, as they would in any case. But they would listen very carefully to what Mr. Osuna said in his innocent defense, in his version, if it was an exculpatory version. And I think he'd be well prepared as a witness, and because there's, as far as we know, no smoking gun independent evidence, he probably would have been acquitted. But I can't be sure of that. There's no way to know if there was photographs, injuries, or medical records.
And that's assuming he in fact denies it and he in fact testifies in his denial.
Yeah, we have no idea what this is, and this is a problem.
Now, for a lot of people thinking that, there's the defense, there's the prosecutors, and then there's a judge. But there's no judge in what happened here.
Well, there was a judge that was sitting at the front of the courtroom that
but Barry's right.
accepted the peace bond. He wasn't, any adjudication would have been him giving his opinion behind the scenes in the judicial pretrial, but he didn't judge anything.
Right. Well, if the Crown at any point, having spoken to this woman, knowing facts that we don't know, if they for 1 second thought that Roberto Osuna was dangerous or risk to other people out there, what could they do? Where would they go to say, okay, listen, There's a peace bond. The charges are being dropped. However, this man could be dangerous to society or to other women out there. So we need to make sure that this doesn't happen. Who do they say that to? Who do they bring that up to?
The police reports would be available to the Houston police if they want them.
Right.
If they call Toronto and say, what do you got on Osuna? They'll share. They'll share it through police information sharing through the computer systems, and any detective would probably share with his brethren in Houston. The Crown did all they could. If they think he's dangerous but they have no case, they've done pretty much all they can, which is to get him to sign an order to comply with, can comport himself with good behavior. There's not much else they can do because they don't have a case.
And because we don't have the facts, there is the possibility that there could be, and again, not necessarily in the Osuna case, but in general, there can be people out there that are dangerous that are just free to walk around because there's no one there to prove otherwise. And they'll have to do something again before anyone can say, you see, well, yeah, he should have.
That's the reality of living in a free society. In authoritarian societies, you're going to see more of that, where the state is going to go and arbitrarily imprison people that they're concerned about. Part of the cost of living in a free society might be a little bit more crime than some of these other places
Minority
to live.
Report. Minority Report was predicting future crime.
Right.
Science fiction theory about arresting people for future crimes. We have only the narrowest versions of that with preventative recognizances and whatnot. But that's sort of what a peace bond is worried about the future.
While there's no criminal charges against Roberto Osuna, he's free to come and go in and out of the country. Is there going to be any kind of a black mark on him? Is there anything that in the future, if something happens, he has this, like it's almost like a warning or a strike one or something that's going to be written down somewhere about this?
It's an excellent question, and it's very relevant to average members of the public. It may not be relevant to Osuna because he's got huge moneyed employers with immigration lawyers and everything ready to make sure that he doesn't have any prejudice. But your average person signs a peace bond, it can be a determination that the case did not end in their favor, and when they apply to be a scout leader, hockey coach, police officer, security guard, any profession where there's going to be a level of trust working with a vulnerable sector, nurse, teacher, as I say, even volunteers on school trips. I had to get a vulnerable sector check to go to the University of Waterloo with my son for an orientation.
Right. And if you had a peace bond, they would see it's there?
They would see it's there, and the police could fail me on it.
You always hear about celebrity cases, more in the States, probably always in the States, about where you have that hush money. We'll pay you some money, and you keep your mouth shut, drop the charges and whatever. And a lot of people out there have speculated that this has happened in this Roberto Osuna case. First of all, is it legal in Canada for the defense to pay off a defendant with hush money and say, we'll give you this $1 million check, and all you have to do is drop the charges and agree to a peace bond? Is that legal?
Absolutely not. That's obstruction of justice.
But it happens in the States all the time. Is it different there?
I don't know exactly how it happens in the States. It happens in Canada sometimes, and if it's done above board as a civil settlement in lieu of proceeding with a criminal matter, it's tricky, and it's got to be done very...
It's how you word it, right?
Very
hush
much.
money bad. Civil,
Very much. I think in this case, without even saying it, there is a concern that the complainant governed herself as a witness, knowing that she wants child support for the foreseeable future and would really like it if the person paying that had their career unabated.
Or just was a case where she wants to continue a relationship with him.
Like many, many women who, whether he's a breadwinner or not, many women continue relationships against anyone's better judgment with men in their lives because of some sense of personal security that they take some comfort from and rightly or wrongly believe that putting a matter behind them is better for their relationship. And in the Osuna case, it's very tempting to say, I want him to re-sign with Houston or re-sign with the Yankees or the Dodgers in the next few years and make $50 million, $150 million, whatever it's going to be. That's going to be very good for my child. If he is gets a full year suspension, if he does jail time, if promotional materials, if Avocados from Mexico no longer wants to be sponsored by Osuna, or if any other opportunities he has in the promotions world are going to be hurt by this, it's better for me and my child if he moves forward unencumbered. And that is tempting to think that's the case, but every case is going to have a myriad of nuance in the consequences for the complainant. Bringing the police and the courts into your lives is disruptive. It's necessary for public safety sometimes, but it is disruptive and uncertain. And when you have a resolution like this that makes everybody seemingly move forward peacefully, it's hard to criticize it from anyone's role here. I don't like the fact the Crown wasn't more transparent about what the allegation was. I don't see the big secret. The public doesn't have a right to know, but the view that domestic violence is a private matter that is long past. That domestic violence is a societal problem that should not be relegated to the shadow.
Adam Goodman, Scott Cowan, thanks as always, gentlemen. On the next show, we will get to the topic that we wanted to get to. But for now, hey, we can finally put this Roberto Osuna case to rest until there's more to talk about it. We want to thank our producer, Matt McFarland, for all his fine work as well. And guys, this court is adjourned.